Welcome. The following presentation will cover the basics you need to know with regards to sexual misconduct compliance at FSU. Once you are settled into your new job, or if you have any questions, I recommend you attend further training or reach out to the Office of Equal Opportunity and Compliance. This presentation will cover the sex discrimination and sexual misconduct policy, as well as associated parts of the equal opportunity, non-discrimination, and non-retaliation policy. Additionally, we will cover prohibited conduct, both examples and corrective action, how to prevent and respond to sexual misconduct related to complaints, reporting requirements, and bystander intervention. Additionally, we will cover non-retaliation requirements and the Vulnerable Persons Act. The university's primary non-discrimination policy is the Equal Opportunity, Non-Discrimination, and Non-Retaliation Policy. Together with the university's Equal Opportunity and Non-Discrimination Statement, they establish all protected groups recognized by the university and set forth complaint and investigative procedures. Because requirements related to sexual misconduct are more nuanced, the university has a dedicated sex discrimination and sexual misconduct policy, which is accompanied by a Title IX statement. A copy of the Title IX statement is provided for you as a handout. This presentation will review key pieces of the sex discrimination and sexual misconduct policy, hereto referred to as the policy. First and foremost, the policy is applicable to everyone. That means all employees, including faculty, staff, and OPS, all students, and all other third parties. The policy applicability is twofold in that it both provides protection for, but also sets expectations of behavior for all. The policy is effective 24/7 and applies to both university programs and activities, in addition to incidents that happen outside of the university's purview and that have consequences that carry over to the workplace or academic environment. Starting with the basics, equal opportunity non-discrimination means that all employment and educational decisions from application through separation may not be based on a protected group. For this presentation, I will specifically be referring to the protected groups sex, gender identity, gender expression, and sexual orientation. FSU employees, students, and third parties may not limit someone's employment or educational opportunities, take negative employment or academic actions, create a quid pro quo environment, or create a hostile environment based on a protected group status. Doing so would constitute sexual misconduct under the policy. Sexual misconduct is an umbrella term. Specific behaviors that constitute sexual misconduct and are expressly prohibited by the policy are gender stereotyping. Gender stereotyping is defined as an overgeneralization of characteristics, differences, and attributes of a certain group based on their gender. Gender stereotypes create a widely accepted judgment or bias about certain characteristics or traits that apply to each gender. Examples are: women are supposed to be shy, passive, and submissive. Women are organized and clean. Men are expected to be tough, aggressive, dominant, and self-confident. Men are lazy and messy. Gender-based animosity. Gender-based animosity is the hatred of, contempt for, or prejudice against someone based on their gender. An example would be, transgender people should just get over it and be the sex they were born as. Pregnancy discrimination. Pregnancy discrimination is treating a female employee or student unfavorably because of their pregnancy, childbirth, or a medical condition related to pregnancy or childbirth. Examples are refusing to hire or not providing appropriate, reasonable pregnancy accommodations if requested. Sexual harassment. Sexual harassment is quid pro quo and hostile environment. We will discuss them more in detail shortly. The next behaviors we're going to cover are also criminal in nature. Regardless of any type of criminal investigation, the university still has an obligation to address the situation. In fact, there are many services and resources that must be offered internally. Even if the person accused of the situation is not affiliated with the university, we can still provide services and resources to the affected party. Sexual violence. Sexual violence is any sexual act performed without consent, also known as rape, sexual battery, and sexual assault. Dating and domestic violence. Dating and domestic violence is violence between an individual who is or recently has been in a continuing and significant relationship of a romantic or sexual nature and another party, or violence within a family and or household. Sexual exploitation. Sexual exploitation is any act of taking non-consensual, unjust, or abusive sexual advantage of another person for one's own advantage or benefit, or to benefit or advantage anyone other than the person being exploited. Examples include non-consensual videotaping, photographing, escort services, or knowingly transmitting an STI. Stalking. Stalking is an intentional course of conduct repeated over a period of time that is typically invasive and meant to intimidate. Under this policy, the behavior would be associated with a past relationship or interest in a future relationship. Examples could be appearing at a person's house, class, or work, frequently calling or texting, using social media, or vandalizing another person's property. Whether for your own knowledge or for recognizing signs of what could be a sexual assault when receiving a disclosure, the key is understanding consent. Receiving consent is critical for any kind of touching, both social and sexual, both in the work academic environment and out. In order for consent to be valid, it must be given when someone has the mental capacity to do so and understands what they are agreeing to, such as intelligent and knowing. It also needs to be straightforward without any hidden agenda, unambiguous, and not coerced in any way, either directly or indirectly, meaning voluntary. Consent is active. It does not always have to be verbal, but the other person needs to demonstrate a willingness. Failure to say no, distance yourself, or fight back does not mean yes. Even if consent has been given, it can be withdrawn. If you receive prior consent, it does not mean you have future consent. Getting consent has to occur every time. Consent, even if given, is not valid if someone is significantly impaired by drugs and or alcohol. Think about it this way. If someone is not sober enough to safely drive a vehicle, then they are not sober enough to give consent. Even if someone is giving verbal consent, if they do not presently have the right mental capacity to understand what is going on and to make a clear decision, the situation is a no-go. Consent is also invalid if someone is asleep, passed out, unconscious, or has a disability. Also, if someone is a minor, meaning under 18. In Florida, we have a law that allows consent when the parties are age 16 to 24, but outside of that, each party must be a legal adult, at least 18. Additionally, consent is invalid if someone is bribed, threatened, or physically forced. This is any kind of intimidation or coercion, both direct and indirect. Sexual harassment as a term is interchangeable with sexual misconduct. As defined in the policy, it refers to a quid pro quo and hostile environment. Quid pro quo is the creation of a situation where a person in a lesser position of authority or power is either rewarded or punished by the person of greater authority or power based on their submission to or rejection of sexual or romantic advances. It is important to understand that these situations can also be created based on perceived authority, even if there is no real authority. For example, a teaching assistant, TA, might not believe they are in a position of authority if they are not the instructor of record and it is their supervising professor who assigned grades. However, the students will not understand those nuances. They will perceive the TA as having authority influence over their grades. Therefore, what might be a simple invitation to lunch may be interpreted as more. Consider a situation from the other person's perspective before acting. Here are some other examples. More straightforward. You do me this favor, and I can guarantee you the job. Whether the person actually has the authority to get someone the job is irrelevant. If they have capitalized on the perception, they are using coercion. Here's another one. Don't worry about being out of work. I will make sure you get your 40 hours on your timesheet. Whether as an enticement to start a relationship or as a benefit of being in a relationship, it is fraud, and the person of greater authority will be held accountable. And finally, you know what you have to do to get on the merit pay list. Well, this could mean that you need to be on time, do your job, and provide additional assistance when needed. But if it is followed by a wink wink, a caress, or a see you this evening, then the meaning is that submission to or rejection of will become the criteria for receiving merit pay. Intentional and perceived quid pro quo situations can be mitigated by making sure decisions are not made in a vacuum. The more oversight, the more it creates a check and balance. The more commonly occurring type of sexual harassment is the creation of a hostile work or academic environment. There does not have to be an authority power differential. It just takes someone, whether intentionally or ignorantly, behaving inappropriately related to sexual or gender-based conduct. A hostile environment is created when the unwelcome sexual or gender-based comments, actions, behaviors either 1. Unreasonably interferes with an individual's access to opportunities or benefits, such as work, class, activities, events, or 2. Are significantly severe, frequent, or pervasive enough that they result in an intimidating, hostile, or offensive environment. Severe means that a single occurrence of the conduct is sufficient enough to create a hostile environment. For example, unwelcome kissing and groping or an altercation with derogatory language and threats are likely to immediately result in a hostile environment. Frequent and pervasive refer to conduct that is not severe, but though a cumulative effect built up to a hostile environment. For example, unwelcome hugs or general offensive language might be something that someone tolerates in a limited capacity, but if the behavior continues, escalates, or more people start doing the same, it will become a hostile environment. It is your responsibility to not willfully do anything that is inappropriate, but also to gauge the reaction of others to minimize ignorantly making someone uncomfortable. For example, if you reach out to hug someone and they either hold out their hand for a shake or lean in for a hug but do not actively participate, they are not consenting to a hug. You are also expected to help monitor your environment, especially if you are a supervisor. Behaviors need to be stopped and addressed before they create a hostile environment. Other examples of behaviors, actions that can create a hostile environment include uninvited touching, including hugs, and other sexually suggestive comments, inappropriate displays of sexual posters, photos, cartoons, obscene gestures, sounds, jokes, practical jokes, emails, texts, and leering. More examples of behaviors, actions that can create a hostile environment are using gender-based derogatory language, remarks of a sexual nature about a person's clothing or body, asking questions or speculating about someone's sexual experience, performing sexual gestures or touching oneself in front of others, allowing others to harass a colleague who is transitioning from one gender to another. The university specifically recognizes gender identity, gender expression as groups protected from discrimination. Make sure you are using a person's preferred name and pronoun. Other conduct includes continued unwelcome flirting, requests for dates. The university prohibits relationship between individuals that create a conflict of interest, such as one party has supervisory or institutional authority over the other. If you do pursue a relationship in the workplace, remember your behavior should be respectful and that all responses other than an unequivocal yes mean no. Understand that due to workplace dynamics, the other person may not wish to offend you with a negative response. They may instead be evasive or non-committal. This does not mean try harder. Also, inappropriate conduct is going to be sexual violence and/or dating and domestic violence. As an employee and as a student, you can receive corrective action if you engage in sexual misconduct, including sex or gender-based discrimination, are complicit in an act of sex discrimination or sexual misconduct, knowingly file a false claim. To clarify, a report that does not rise to the level of a policy violation is not considered a false report. Corrective action if you retaliate against someone, or if you fail to comply with mandatory reporting requirements or fail to enact interim measures. Corrective action is up to and including termination for employees, expulsion for students, and no trespass orders for visitors, vendors, and other third parties. If you need to report an act of sexual misconduct based on your own experience, or if someone discloses to you, the university has dedicated employees who handle these matters. If the person being accused of the behavior is a student, then the report or complaint needs to go to the Title IX director and the Title IX office. If the person being accused of the behavior is an employee or other third party, then the report or complaint needs to go to the Office of Equal Opportunity and Compliance in Human Resources. The most straightforward way to make a report or complaint is to go to report.fsu.edu. Please remember that we are all here to help each other out. So it is probable, that a student or one of your coworkers may disclose to you information of a personal nature or share situations that are making them uncomfortable. They may not go directly to the Title IX director or the Office of Equal Opportunity and Compliance to make a complaint. Part of the university's expectations are that you are creating an environment where someone feels like they can get help, but also when they do, you are expected to know how to report the information you receive in order for them to get help. It is going to be your responsibility to file a report. The university encourages the reporting of all incidents, as we can't help if we don't know. But there are times as an employee when you will be required to file a report. You are considered a responsible employee with a mandatory reporting obligation if the 1. Affected party is a student, 2. The affected party is someone you supervise, 3. The incident involves sexual violence, or 4. The incident involves a minor. The report must be made within 2 days to the Title IX director or the Office of Equal Opportunity and Compliance. To make a report, you can go to report.fsu.edu, send an email, or make a call. Remember, even if you report the information to others, like FSU PD, your supervisor, or the Victim Advocate Program, you still need to make an official report. In situations where you are a responsible employee, the reporting trigger is anything that you know or should know. This includes a duty to file a report and respond if any individual mentions or tells you, even if it is a second or third-hand report, meaning a coworker, police, or media are sharing the information with you. You must respond and report if the affected party or the responding party, meaning the accused, tells you directly that an incident occurred or that they are being accused by another. If you witness, see, or hear a situation, or if you hear it through a rumor mill. When in doubt, file a report. Although a person may ask you to keep something confidential, if it is a situation in which you are a responsible employee, then by policy, you cannot. You need to file a report. What you can do is reassure the person that the information will be handled privately and that the Title IX administrator who reaches out to them will discuss confidentiality options with them. The only employees on campus who are confidential sources from minute one are the FSU Victims Advocate Program, mental health counselors at the University Counseling Center and the Employee Assistance Program, and medical staff at the University Health Center. If you are in a situation where someone is disclosing information of a personal nature or about something that makes them uncomfortable related to sexual misconduct, you should reassure the individual that you are available to listen and help. Let them know that certain things they may tell you about, such as discrimination or sexual misconduct, will require you to notify the Title IX administrator, and that requests for confidentiality can be made to the Title IX administrator. If you're able to talk to them before they actually disclose specific information, you can provide them contact information for the Victims Advocate Program or take them directly to the office. If they have already disclosed, make sure the person is immediately safe, help the individual contact the Victim Advocate Program, and if requested, call the police. Let the person know who you are making your Title IX report to and that a Title IX administrator will be in contact with them. Then report to the Title IX office or the Office of Equal Opportunity and Compliance. Key to being a good listener and being able to get the individual who disclosed help is to not do or say anything that could be perceived as victim blaming. Whether you have a long history with a person or if you just met, make sure you are only acting within your role at the university and are not doing or saying anything that creates doubt of your belief of their experience. You should avoid saying things like, "Did you do anything that could have been misinterpreted? What were you thinking? You should have known better. Were you drunk? What were you wearing? Why didn't you fight back?" Yours is the role of listener and reporter, not investigator or judge. Instead, you can say things like, "I hear you. I see this has clearly upset you. I understand you are saying this has been," and then go on to describe what they have reported to you. Is there something specific I can do to help? Can I get you in touch with a victim advocate? Or can I get you in touch with the police? We have gone over in depth what to do if someone discloses to you related to a situation that has previously occurred. In addition to your reporting obligation, the university also asks that you be willing to intervene during active situations as a bystander. If you are witness to a situation unfolding that could be prevented or mitigated by getting involved, then we ask that you do so without risking your own safety. There are 3 general approaches to bystander intervention. The first is direct. Do something that lets the people involved know that you see what is happening. This can be as simple as a check-in. The second is delegate. Engage help from others, including calling the police if needed. The third is distract. Think of a distraction that will diffuse the situation or calm things down in the moment. The idea is not to disregard the situation as not your problem. The question to ask is, would I want someone to step in on my behalf? If yes, then are you willing to do the same for others? The university wants to ensure that everyone feels they can speak up and get help if needed. To that end, the university prohibits retaliation against anyone who makes a complaint, be it internal, external, or even a lawsuit, helps someone report or fulfills their reporting obligation, participates in investigation. This includes the complainant, witnesses, and the accused, or someone who otherwise opposes discrimination. An act of retaliation is defined very broadly. It is considered any action that could discourage a complaint from being filed or continued, any negative employment or academic action because of a complaint, or creating a hostile environment because of a complaint. Even if it is determined that the underlying complaint was unsubstantiated, if any of the mentioned actions occurred because someone participated in a protected activity, that is a distinct violation of the policy. We also want to make you aware of your reporting obligations related to the Florida Vulnerable Persons Act. This law is applicable to you as a Florida resident, not just as an FSU employee. The law requires that if you know or suspect that a child is being abused, abandoned, or neglected, you must report it to the Florida Department of Children and Families. This is applicable both on and off campus. Each individual in the know has a distinct reporting obligation. If the situation is occurring on campus or during a university activity, you should also call the FSU Police Department. Thirdly, if the incident involves sexual harassment, violence of a minor, it should be reported to the Office of Equal Opportunity and Compliance. If there is an immediate threat or medical emergency, call 911. Here is a list of available resources. The Title IX Office, 850-644-6271, or nomore.fsu.edu. The Office of Equal Opportunity and Compliance, 850-645-1458 at compliance.hr.fsu.edu. FSU Police Department, 850-644-1234, police.fsu.edu. Victims Advocate Program, 850-644-7161, dos.fsu.edu/VAP. University Counseling Center, 850-644-8255, counseling.fsu.edu. Employee Assistance Program, 850-644-2288, eap.fsu.edu. University Health Services, 850-644-6230, uhs.fsu.edu. To make a report or get help, contact Human Resources, Equal Opportunity and Compliance, 850-645-6519, or eoc@fsu.edu, or go to report.fsu.edu.